Do you remember a while ago when we were first talking about the California AB5 law?
Remember TIE fighters? Oh, remember Jawas? Remember? Hey, remember Jurassic Park? Oh, you love Jurassic.
Basically, AB5 is a California state law that would make it much more difficult for employers to classify workers as contractors instead of employees. Determining their working status would be done using a new test called the ABC test. Ultimately, this could affect around 70,000 owner-operators throughout the state. If you don't remember all of this, we will throw that link above to that original video in case you want more details. Well, after fighting with 4 separate claims to get this law denied, unfortunately on Friday, March 29, 2024, California District Judge Roger Benitez denied the California Trucking Association's and OOIDA's latest request for injunction. This means that there will be no relief to truckers from AB5 as OOIDA and CTA appeal the ruling. If you have any questions or concerns about how the AB5 law will affect you as a trucker, you can talk to one of our specialists by calling, emailing, or filling out the form below. CTA and OOIDA approached the injunctions 4 times and in 4 different ways. Let's do a quick overview of these 4 injunctions. First, they stated that the Federal Aviation Administration Authorization Act, or F4A, preempted AB5. The F4A is an act that forbids states from enforcing a law related to the price, route, or service of any motor carrier. Benitez denied this injunction based on the court's previous ruling that AB5 is not significantly related to rates, routes, or services, and therefore isn't preempted by the F4A. In the second injunction, they said there was an implied preemption because AB5 creates a patchwork quilt of national regulations to classify truck drivers for purposes of wage and hour protection. Benitez disagreed and denied this as well, saying that the particular regulations Congress is concerned about are those addressing a carrier's price, route, and service, not wages and hours. The third injunction claimed that AB5 is a violation of the Dormant Commerce Clause of the U.S. Constitution, which basically says that states cannot pass laws that regulate interstate commerce. Benitez denied it, saying that CTA and OOIDA argued that AB5's burden on interstate commerce outweighs the local benefits, and although AB5 does have economic effects, the effects don't confirm a purposeful discrimination against interstate commerce. Lastly, they claim that AB5 violated the Equal Protection Clause of the Constitution, claiming that employee classifications were targeted at carriers and owner-operators, were not impartial, and were based on comments by the AB5 legislative sponsor, Lorena Gonzalez. Again, Benitez denied the injunction, saying that the statements of the one legislator doesn't necessarily motivate other legislators to vote on passing the bill into law. So if AB5 does not include a trucking exemption, then there will be a flood of independent carriers going through a new hire process, and there are a lot of rules around this process. We do offer a new hire service where all driver files are managed properly and in compliance with the DOT. This single service is also offered as part of our DOT compliance programs. If you're interested, talk to one of our DOT compliance specialists by calling, emailing, or filling out the form below, and we'd be happy to help you.